Hi, Miss Archer, can you hear me?
Okay, you can hear me now, right?
Yes, ma'am, I can hear you now.
Okay, good. All right, so let's get started again. Okay. I just tell Miguel I got it. Okay. So where exactly you want to begin? Because Ms. Dean say, have you done trust before?
I did some of it, but I in a nutshell, not really.
Okay, so you want to start from the beginning?
Okay, we can.
Okay, all right. So let's start from page 4, which is the introduction.
Okay. Okay, I'm here on page 4.
Okay. So the introduction really is just giving you a background to trust business.
Yes, ma'am.
So all it's telling you is that when you study this course, the stage 1 is really about gaining a practical knowledge of trust law and administration of trust. And so what we're going to look at is the roles, the duties, and the responsibilities of the parties to a trust. And the parties to a trust are the settlor, the trustees, and the beneficiaries. So overall, you're looking at the administration of the trust. How do you administer a trust?
Yes, ma'am.
Who do you owe a duty to? And who can sue you as a trustee?
Okay.
So historically, the trust was developed from equity. And equity means to be being fair. So in England, they tried to develop a flexible legal system that would have a remedy to deal with legal matters.
Yes, ma'am.
For like poor people who went to war, they would have left their properties with another individual and say, oh, listen, trust for my children in the event I don't get back. Then it developed over time with people not just going to war, but people traveling or people getting sick and asking people to hold things in trust. So this is developed over the years, and the court came up with a system which says that we have to be able to produce some kind of fairness in terms of the structure of this whole arrangement.
Okay, so let me ask you this. So initially, so it was more of like a verbal agreement?
Yes.
Okay.
Mm-hmm. Yeah, long time ago.
Okay.
So right now, for a trust, it's a written agreement.
Yes, ma'am.
Right. So a trust itself, when you hear someone talk about, I'm holding something in trust for someone else.
Yes, ma'am.
When you create a trust in terms of someone going to a bank and trust company, and you walk in and you say you want to create a trust, or you have a trust in another jurisdiction, you transfer that to the Bahamas. The assets that person owns to be transferred into the trust that asset has two interests. And this is how the trust distinguishes itself from other products that a person would enter into in terms of wealth preservation or estate planning.
Okay.
So when you go to create a trust, the trustee takes the legal interest of that property. And the beneficiaries have the equitable interest. And that's a concept that you have to understand. So if I own 5 pieces of property, some cars, some boats, some jewelry, some paintings, and they're all in my name. To put them in a trust, you have to own them free and clear, which means there cannot be any liens against those property. There cannot be any debt against those property. So say if I own all of these assets now, and I go to a trust company and I say, I want to create a trust for the benefit of my wife, my children, and myself, assuming I'm a man. If it's a woman, the other way around. So when that person goes to that trust company and speaks with the trust professionals and they review the assets, they get the documents to prove that yes, I own properties free and clear. In order for that trust to be created, as you will see when we go further down, you then have to convey or transfer the title of those properties in the name of the trustee.
Okay.
So it'll go in the name of the company.
Of the trust company. Okay.
Yeah. The equitable interest, which is something you cannot touch. The equitable interest is for the benefit of the beneficiaries. That interest is what gives them the right to sue. And that right to sue is based upon whether a trustee breaches his duties, one of his duties, or some of his duties.
Okay.
So the attraction of creating a trust is for protection of assets, is to create profitability because the trustee will administer and manage the assets of your trust. Because once you put assets into a trust, you no longer own those assets anymore.
Okay.
The only way you could benefit from that trust is if you make yourself a beneficiary.
Oh, okay. You mean like you said, if you were leaving something in trust to your wife and your children, you would then add yourself in that as well. And that's
Yes,
the only, okay.
that's the only way you could benefit from it.
Okay.
So the Bahamas, as an offshore jurisdiction, promoting trust business,
Mhm.
it does based on the existence of confidentiality and data protection. Remember, confidentiality and data protection are the bedrock of our financial center. And that is enshrined in our law in Section 77 of the Banks and Trust Companies Regulations Act.
Okay.
In addition to that, we both having a sound legal system because our laws is based on common law. We are a part of the Commonwealth. So we can always refer to cases that were tried in other common jurisdiction. We also boast when they go out to talk about the Bahamas and promote the Bahamas that we have a high caliber of trust professionals.
Okay.
We have a stable political system. And of course, all of our professionals in trust business are trained.
Okay.
And this is the first step in the training, this course right here.
Okay.
So the responsibilities of a trust officer are quite onerous. And you'll see that when you do the chapter on trust, the trust administrator. And you have to take, as a trust administrator, you have to be analytical. You have to be detailed. You have to be focused. And there are other things as we go through the units, you'll see that you need to know. But more importantly, a trust officer has to make sure that he or she minimizes or mitigate against the risk. And there are different risks that can happen in a trust. The risk of not breaching one of your duties, a risk of money laundering, risk of terrorism, all those different risks come up. So in addition to looking at the assets and having the assets conferred from the settlor to the trustee, the trust itself have to meet international standards. The trustees also have to do customer due diligence. And because there's so much crime going on, the responsibilities and the duties of the trustees become more challenging and more demanding. Because he has to think about international tax. He has to think about inheritance. Depends on the jurisdiction he's from. If he's from a civil jurisdiction, he have to think about forced heirship laws, which do not allow a person to write a will to benefit whom they wish. The law stipulates who can benefit, die. But
Okay.
yeah, only Commonwealth jurisdiction, you can sit down and write your will as to who you want to give your monies to. In civil jurisdictions, you cannot do.
Okay.
So regulatory oversight for the trust business or the trust industry is by the central bank. So we have different types of trust companies. You could have a public trust company like Credit Suisse, EFG, Rhone Trustees. Those are public trust companies. Then you have restricted trust companies, and those restricted trust companies can only manage no more than 3 to 5 trusts.
Okay. We have restricted trust companies out?
Yes, we do. Yes, we do. And then we also have private trust companies. If you've heard of that, you heard of private trust companies?
Yes, ma'am.
Okay. And so private trust companies, that's where they manage the trust themselves. And it's normally a family.
Okay.
So in the Bahamas, the function and uses of trusts have been enhanced through our trust legislation. So you're taking this exam in a couple of weeks. So when you reread the manual, you have to read it in conjunction with the Trustee Act.
Okay. That's
you're gonna
1998?
Yes.
Okay.
And the amendments.
2011.
Yeah, and there are others. I think there's another one.
Okay.
All right. So why would a person want to create a trust? Like I said earlier, estate planning could be for special needs of your children. It could be just to protect your assets. If we could do it for investments, you could do it for charity, wealth management, financial planning, to manage your assets, or for privacy. And last but not least, which a lot of people do, is to avoid probate. So you understand probate?
Yeah, yes, ma'am.
Okay, all right.
That's when there is no trust or will, right?
No, probate means when a person dies. They die either with
Yeah.
a will or without
They
a will.
die with a will?
with a will or without a will. The
Oh,
process.
I just thought it was when they die without a will. Okay.
No, probate is the process.
Okay.
So if you die with a will, you go to probate, and the court will look at the will, make sure all the assets are being ascertained, they're ready to be distributed by the executor
Okay.
or the attorney. If you die without a will, then the court is going to issue, the probate registry is going to issue you a letters of administration, and the distribution will be in accordance with the rules in the Inheritance Act.
Okay. Got it.
Got it? Okay.
Yes, ma'am.
So on page 6, it says, whatever the reason for the creation of a trust, the responsibilities and duties of the various parties to the trust, particularly the trustee, is important to ensure that the legal and beneficial ownership of the property of the trust are protected and preserved in accordance with the trust instrument and or applicable trust law. So when that said law sits down and that trust is created, if you look at the back of the Trustee Act, you're going to see a template of a model trust deed. So that settlor would sit down and go through the trust model and see what provisions they want to include, which what they want to delete, what they want to expand or add to, amend. All of that is what they sit down and do. So in order for a trust to be valid, there are some formalities, and we'll go through those in the next chapter. So for the legal rights and actions of the beneficiaries, as well as for the duties of the trustees, those things are important to identify and to establish whether there being a legal liability owed by the trustees. Because you're going to find out as you go through the chapters that the duties of the trustees are onerous. Actions for breach of trust do not have statutory protection of law. But then there are other actions on the part of the trustee that may be protected by legislation. So over the years, equitable principles have been replaced by common law principles in trust cases. So in the past, when trust first came out, everything was based on the equitable principles. Now, what the courts follow is the principles that have been established in the trust law cases. And they do that again to make sure that they are fair.
For fairness. Okay. Yes, ma'am.
So there are different types of trusts, and they have enabled various commercial and charitable objectives to be achieved through using a trust vehicle. And like I say, it could be for philanthropic, it could be for wealth, it could be for asset protection, it could be for financial planning. So on page 7 through 8, 9, and 10, yeah, those you could read. All they're simply telling you is that to establish a trust company in the Bahamas, you have to apply to the central bank. And when you apply to the central bank, you have to state what type of trust license you're seeking. And then it tells you the different types of trusts there are. Unrestricted trust, which is open to the public. A restricted, which is one where there are 5 individuals who want to establish a trust. The unrestricted is normally left for large companies, well-known companies that already have established trust business. So you could have an unrestricted, or you could have a restricted, or some entities have a nominee trust service license. And that nominee trust service license operates to provide corporate directors and officers And then, of course, you have the non-active status, and that's when a company is in liquidation. So the central bank prefer their trust companies to be either a subsidiary or a branch, or it can be a standalone. But for a standalone, you have to have that experience and knowledge in order to operate that trust company. So the central bank, normally the first process is you would prepare your plan with your financial projections, and then you would have an interview with the regulator. The regulator then would ask you questions. You may have to make some amendments to your proposal before you make your final submission. And of course, like any other company, when you're coming to a regulator, there's a standard as to how much capital your company can have. And because it's trust business, you also have to have indemnification policy. Indemnification policy. So only thing after that on page 9, I've set out what should be in your proposal to the central bank if you wish to obtain a license to do trust business in the Bahamas. And all it says is you have to give the regulator the name of the trust company, the address, or the head office or the registered office of that company, what is going to be the year end, who are the auditors, who are the shareholders, how many shareholders do you have, references on the shareholders. You normally would give a CV, a financial reference, a personal reference, a police certificate. You'll also tell the regulator who are going to be the proposed directors and officers, partners and managers. You also have to do a capital outlay as to how much capital the company will have with the projections and going forward. A copy of your certificate of incorporation, because don't forget you have to incorporate a company before you apply to the regulator. The constitution of that company. If it's a trust company that's already in existence, you'll have to provide the financials for that company. Then you have to let the regulator know about your internal controls. And of course, all plans going to a regulator have to have a 3-year projection because they have to see that you have sufficient funds in order for that company to operate. Any questions? Ashay? No questions?
Oh, I didn't even realize I was muted. No, ma'am, I have no questions. Hello?
Okay. Yes, I hear you.
Okay.
On page 11, going from the bottom, the Financial and Corporate Service Provider Act, that should be 2020.
Okay.
Going up, the Central Bank of the Bahamas Act should be 2020.
Okay.
And the Banks and Trust Companies Regulations Act, that should be 2020.
Okay.
So these are all the laws that govern trust business.
Okay.
All right. So let's go to Unit 1. So at the introduction, I told you that trust is something that evolved in the legal system in England, and it had to do with fairness. And over time now, we use trust cases. But that fairness and that equity developed over time, over years. And you'll see when a judge makes a ruling in a trust case, you'll see him use certain phrases. Those phrases come from what we call the maxims of equity or equitable maxims. So these are the principles that the judges would have used all the way back to the 1700s.
Okay.
So the first equity you would hear them say is equity will not suffer a wrong without a remedy. means that when you come before the court and you have been wronged, they're going to find a remedy for you. The next one is equity follows the law. So that one is simple
Yes, ma'am.
or says. The next, where there is equal equity, the law shall prevail. Again, looking at equality. Where the equities are equal, the first in time shall prevail. So that means that if you purchase a piece of property and I purchase a piece of property, whoever goes to the registrar first,
Okay.
they have it registered,
Yes, ma'am.
that property.
Okay, so we referring to the same property?
Yes.
Okay.
Mm-hmm. That's what first in time means.
Okay.
So that would have, you'd have seen a lot of that in the early days, like the 80s, when someone had a piece of property, they'll mortgage it with Bank A, and then it will go to Bank B and mortgage it with Bank B. Now, Bank A, all about dilly-dallying, deciding that they probably won't get their property is registered all like right away. They'll wait for a bundle. Whereas Bank B decides that they're doing theirs the next day. So they would have a first lien over the property before Bank A, even though Bank A would have issued their mortgage on the property before Bank B.
Okay.
Yeah. So the next maxim is he who seeks equity must do equity, which means that you have to be fair. You cannot be to the court asking for the court for the person to be fair with you, and you haven't been fair with that person. He who comes into equity must come with clean hands, which means that if you have done someone wrong, you cannot come to the court asking the judge to give you a remedy when you know that you did not act fairly towards the other person. Delayed defeats equity. So that's the same thing like I was telling you with the mortgage. If you take too long to process your documents, then you don't have an equitable remedy. Equality is equity. Again, is looking at what is fair. Equity looks to the intent rather than the form. So you find sometimes what the court does is the court looks not at the form, which means the document, but look at what the parties to the document had intent, what was in their minds when they decided to enter into that agreement. Equity looks on that as done, which ought to be done. Here, the court looks at if you're in a contract and we have started the process, we have done what needed to be done in order for the matter to continue, and one party decides to drop out, the court says no. They look at what is done as what ought to be done, and they have to complete it. Equity imputes an intention to fulfill an obligation. Again, if you enter into arrangement, the court looks at what is your intention, and it imputes in that an equitable principle, in that it looks at what was your intention and what was the obligation to the other party. And last but not least, equity acts in personam. So equity is not in realm, it's not against the whole world. Equity is against you, or you against another person. It cannot be you against the whole world. So when a beneficiary wants to sue, the beneficiary has to sue the trustees. So what's a trust? A trust is a legally thing in which a person known as a trustee holds, manages, administers the assets that are being transferred to him by a settlor. for the benefit of the beneficiaries. So in your notes, I give you another legal definition, which is an equitable obligation binding on a person who's called a trustee to deal with property over which he has control, which is called a trust property, for the benefit of persons who are called beneficiaries, of whom he may himself be one, and any one of whom may enforce the obligation. Any act or neglect on the part of the trustee which is not authorized or excused by the terms of the trust instrument or by law is called a breach of trust. So there are many different types of trusts. You could have a simple trust, a special trust, statutory trust, express trust, executed and executory trust, completely and incompletely constituted trust, private and public trust, discretionary fixed trust, protective trust, secret trust, charitable trust, purpose trust, implied and resulting trust, and constructive trust. Now, those two last trusts, number 12 and 13, those are not types of trusts that a person would go into as an arrangement. Those 12 and 13 arise by law. So one of the key things you have to understand is to be able to distinguish a trust from other products.
So, sorry, I have a question.
Go ahead.
Okay, so
This button.
okay, so you say 12 and 13 arise by law. Is that how with the, oh gosh, when they don't have a, sorry, 1 second. Okay, that's like when you go to court with the, for the probate and they don't have a will and the judge, I guess, makes a decision based on.
No. So a resulting trust is when you have, let me see, you make an arrangement.
Mhm.
You make an arrangement between two persons. Two persons make an arrangement, and something happens during the course of that arrangement whereby the legal effect of the trust doesn't happen. And so it goes back to the settlor.
Okay.
That's a resulting trust. Constructive trust arises. You see it, you can see it in banking. Or you can see it in the trust when someone fraudulently receives monies from a trust, then they hold those funds as a constructive trustee by law because it's not theirs.
Okay.
But all the other ones, you would never see a trust instrument with the heading on it, discretionary. You'll know the type of trust it is by the clauses.
Okay.
Within the trust instrument.
I got that.
Yeah. We'll look at some of them in a little bit. Let me see, my page is all over the place. Let's go. So you have to distinguish a trust between other relationship. So the first one is bailment. Do you know what bailment is?
Yes, ma'am.
You do? What's bailment?
So bailment. Even though they might have some similar characteristics, bailments could only be made of chattels, while trusts could be made of all forms of property.
What does that
So,
mean?
so I'm assuming that the difference between the bailments and the trust is that you you could, I guess, put whatever you want inside a trust.
Mm,
Like,
not
when I say
no.
whatever, it's a trust could be made of all forms of property. So it doesn't. The trust doesn't you. It doesn't specify one particular thing.
Okay. It's not just about the property. Now, remember now, this is trust law. So you have to start to think in terms of law. So I said to you that a trust is a legal arrangement
Yes, ma'am.
where the settlor transfers the assets to the trustee to hold, to administer, to manage for the benefit of the beneficiaries.
Correct.
Bailment is where you go to a bank, and that service is actually being discontinued in most banks now, and you open safety deposit box and you put things in it. That's bailment.
Oh, okay.
So if you look at a trust and the role of the trustees, that's not the same as bailment. The bank doesn't have any legal title to your property. The only thing that the bank it has the duty to is to make sure that your property is secure, that
Yeah.
it doesn't incur the thought of conversion, which means it doesn't give your property to the wrong person.
Yeah. So it's like they just holding your property in safekeeping, and you go and get it whenever you want.
Yes.
Okay.
That's the difference between a trust and bailment. Now, agency. What's the difference between a trust and an agent?
So an agent has possession of the principal's property, while a trustee has a bare legal title.
Okay. And so the key thing is that in a trust, the relationship is proprietary. He owns that property. But in an agency, it's a personal relationship between the agent and the principal.
When you say in an agency, it's a personal relationship. What exactly do you mean?
Okay, so when let's say you're working for a company.
That's right.
And your job is to go and have documents signed on behalf of the company, or you're going to make deposits on behalf of that company at a bank.
Mm-hmm.
You're acting as an agent.
Oh, okay.
Of the company, yes. A trustee does not act as an agent of the settlor. That's not his role. His role is to hold, to manage, and administer of the trust for the benefit of the beneficiaries. And he holds the legal interest in those properties. That agent has no interest in no property.
Okay.
A contract and a trust. A contract is a document that is enforceable in law. It could be under a seal or not. And only the parties to that contract can sue each other. But a trust can be enforced by a volunteer, which means someone who is not a party to the trust, but who has an interest in the trust. And then you have to distinguish between a trust and a power. So a power, when you read a trust deed, you may see where it says a provision, where it gives a certain person a power. And there are two forms of power. There's either power over disposition of property, that's called a power of appointment, or a power on how to deal with property.
Okay.
So a power and a trust are different in that a trust is imperative, a power is discretionary. So the person who's giving the power of appointment within a trust deed, depends on how it is wording, doesn't have to exercise it all the time. Sometimes the trust gives that person the power to exercise his power of appointment in certain circumstances. Trust is equitable. That's the baby.
Yes, ma'am.
The trust is equitable, and a power may be legal. Because remember, someone, if you're giving someone power, that power can be by power of attorney. And remember, the power of attorney can be limited, which means it can be for one function, or the power of attorney can just be wide. That's me putting on my light.
Okay.
So a trustee is a fiduciary, whilst a holder of a power may not be fiduciary. So there are instances where the court would say that a power holder is a fiduciary, and it depends on the nature of what they're going to do.
Okay.
A trustee may not release his trust, but a power may be released by the holder. Because remember now, a trustee, he can't release his trust. In order for him to leave his trust, he has to find another trustee who's willing to take on that trust. So who the party is? The settlor, like I said, the person who creates the trust, and who at the beginning has both the legal and the equitable interest. Then you have the trustee, and that's the person who's going to hold the assets.
And have the trustee has the legal interest.
Yes. And then you have the beneficiary, who has the equitable interest.
Yes, ma'am.
So like you said earlier, a trust assets could be real and personal property.
Okay.
And all of the assets of the trust is called the corpus. Now, some people will call the trust property subject matter of the trust. So the subject matter, being either real or personal property, could be cash, stocks, bonds, jewelry, paintings. All of those things can be assets, yachts. So normally the settlor agrees with the trustee in advance that he's willing to be the trustee of the trust. Because why he has to ask in advance is that he has to be aware of what are his duties and responsibilities.
Okay.
Because he's going to expose himself to liability. Now, some trusts have more than one trustee. Depends on the size of the trust or the number of beneficiaries. They can have two professional trustees, or they could have a professional trustee and an individual. So beneficiaries of a trust may receive payments from the trust for the duration of the trust for specific or general needs. Remember now, in order to pay a beneficiary from the trust, if the trust is not a discretionary trust, then the trustee would actually stipulate what they should receive and for what purpose. But if it is a discretionary trust, The trustees make that decision.
Make the decision. Okay.
And the trustees will make that decision after they consult with the protector if one is appointed in the trustee. So the settlor has to enforce the provisions of the trust and seek legal action against the trustee if he is a beneficiary. Because if the settlor doesn't make himself, the settlor can enforce the trust, but he only could do that if he makes himself a beneficiary.
A beneficiary.
So a person walks in, they want to create a trust.
Mhm.
That person could be called a settlor, he could be called a donor, he could be called a grantor. Now, in order to create a trust, 3 certainties must be present. You must have intention.
Object and subject matter.
Yes.
Yeah.
You know the difference between the 3?
Yes, well.
Okay. Now, to terminate a trust, that happens when all the income and the capital have been distributed. And a trust doesn't fail for lack of a trustee. Because you could always appoint a new trustee. Now, a trust can also terminate under the rule of Sanders versus Vautier. And in that case, it says that if all the beneficiaries are sui juris, or if there's only one beneficiary, they can have the right to have the legal title of the properties transferred to him or her, so that both the legal and the equitable interests will vest in that sole beneficiary. Now, if it is more than one, all of the beneficiaries have to be sui juris, which means all of them have to be over the age of 18. And the property itself has to be ascertainable. And all the beneficiaries have to be entitled. Now, if there is a class of beneficiaries, and in that class, there are some unborn, some unascertained, and some unascertainable beneficiaries, the rule in Sanders versus Vautier cannot be applied.
Okay.
So we went over the different types of trusts in terms of the names, but you could categorize your trusts. Express trust. Express trust means that's when the settlor goes into the trust company and say, I want to create a trust. Now, there are different types of express trust. Non-discretionary fixed interest trust, discretionary trust, part discretion, part fixed, revocable, and irrevocable trust. So a non-discretionary trust, fixed income trust, is where the beneficiaries are entitled to a fixed share of the assets of the trust. And the right to those entitlements can be enforced by the beneficiaries of that trust against the trustee. Because what the settlor has done is he's actually stipulated how much you are to get and when you're going to get it. So the example say, I give $20,000 to my trustee to divide equally between my children, John and Mary. So what you normally would see was that a person will have a will and they create a trust within the will. You understand that?
They create a trust within the will.
Uh-huh.
Oh, why would they create a trust within the will?
In the will, you see that same statement I have there? I give $20,000 to my trustees.
Yes, well.
That is the trust.
Okay.
So when someone writes a will, they'll say for my executors and the trustees.
Okay.
So they've created a trust within the will.
Okay.
The discretionary one is the one where I'm saying that the trustee makes a decision as to how much the beneficiaries are going to get, when they're going to get it. So you could have a trust that is a part discretionary, part fixed, where the settlor would have stipulated how much a beneficiary is getting in terms of a fixed amount. And then there's a portion of it that the trustees then
The trustee.
expression.
Yeah. So the trust, so they leave a certain amount to, let's say, be divided equally. Let's say they leave $10,000 to be divided equally, and then they leave an additional $10,000 for the trustee to make decision on how they want to distribute it.
Right.
Okay.
So revocable trust means that the trust can be canceled by the settlor. An irrevocable trust is it cannot be canceled by the settlor. After it has been validly created, which means all the assets are transferred to the trustee, then they can't reverse it.
Okay.
Now, to transfer a trust from one trustee to another in another jurisdiction, it must have comparable trust legislation. You cannot transfer trust to another jurisdiction where the laws are not more or less like the same.
The same or similar. Okay.
So you always have to look at what's the proper law of the trust under the terms of the trust deed. And so if the trust law of the deed is silent on the proper law that governs the trust, then you look at what the trust is what is closely connected to. So you look at different factors. You look at where the assets are. You look at where the trustees are, and you look at where the beneficiaries are. Where do they live? So normally is preferred that you select a jurisdiction where the trustees are resident, because then when it comes to a matter being litigated, then you can have it in the courts in that jurisdiction. And if you're having the court in the same jurisdiction where the trustees are, it gives the trustees more protection.
Okay.
So a settlor can also avoid obvious management, control, and taxation problems by appointing trustees who are resident in the proper law jurisdiction. So there's normally a provision in the trust deed itself to cover the power to change the proper law of the trust to that of another jurisdiction. And that power will often be given to the trustees of the trust, and a deed of declaration is executed by the trustees to effectuate the change of the proper law. But remember now, reference should also be made in the trust deed of the desire to change the law of the forum. So if you want to transfer a trust to another jurisdiction, you have the existing trustees appoint new trustees in the new jurisdiction, and then they retire from the trust. And they do that by completing a deed of retirement and appointment. So once the existing trustees retire and the new ones are appointed, the assets are then transferred to the new
jurisdiction.
Right, and it automatically vests in them.
Okay.
Or you could alter the form of the trust settlement, and you could then look at the difference between the English trust law and the law of the country where the trust is to be transferred. And then based on the compatibility, you could then revoke the existing trust and declare new trusts. Everything depends on what the provisions are in the trust deed. Who can enforce it? Who can utilize it? And normally that is left to the trustees. If there's no power in the trust to do this, then the application has to go before the court. And you'll see that when you start to read the Trustee Act, that the trustee has certain powers and he has duties. But when he is in doubt, he goes to the court.
Okay.
So if you're going to transfer a trust from one jurisdiction to another one, there's certain things you would look at. The similarity or differences in the trust law in the two jurisdictions. You look at the interests of the beneficiaries, whether the change of jurisdiction will impact them. You look at the interpretation of certain words based on the jurisdictions. And also you look at the appointment of the trustee in the new proper law jurisdiction. You also make sure that your trust deed has a flee clause. And the effect of that is to change the management and administration of a trust to another jurisdiction on the occurrence of a particular event, such as any political instability, civil unrest, change in taxation policy. You should have a flee clause that tells you it's time for us to pack up and transfer our trust somewhere else.
So if you change jurisdictions, you have to change trustees also.
Yes.
Okay.
Just remember now, if you are sued, it is better to have the trustees in the jurisdiction
Okay.
because it gives them more protection. Because then they'll be looking for protection from another jurisdiction and the assets are in another jurisdiction. The beneficiaries are in another jurisdiction.
Okay.
So the new trustees who are appointed, they appointed under deed of retirement and appointment. And as a part of good practice, they should review the trust laws of the former jurisdiction, make sure they're comparable with their laws. They look at the trust deed itself, make sure that there are provisions in it and that they accept what's in it in terms of what their duties and responsibilities will be, what their powers are, what risk they foresee, what indemnification they will get in order to accept a new trust.
Okay.
And then they should do any investigations that they think is needed, looking at the relationship between the original trustees and the beneficiaries. They also have to look at accounting issues that may possibly arise. So the trust instrument, really, unless it's created by will, it has the provisions of the will, which mention the creation of the trust, the appointment of trustees, the transfer of trust property, and equitable interest of the beneficiaries. The trust instrument may be referred to as the trust deed or the trust settlement, and depends on the parties who author and sign the document. A properly drafted trust instrument would include the parties to the trust property, the trustee duties, the trustee powers, certain powers of appointment, the right of the trustees to receive remuneration, the exercise of trustees' discretion, an exoneration clause from liability for breach of trust, and of course, the power to make capital and income payments to beneficiaries and the variation and the termination of trust. So all those provisions are usually in the trust deed.
Okay.
Questions so far?
No, ma'am, I'm following.
Okay. So 23, the settled law. I already told you the settled law could be the settled law, the grantor, or the donor.
I don't know. Yes, ma'am.
So I don't think I need to go through that. When you read that that's self-explanatory.
Yeah, I already read that. So
Okay.
I get that. I
Okay,
get
so
this. That
okay.
the trustee and the beneficiary.
Okay. So we could go to 4. The
Yes,
3.
ma'am.
Let's go to 3. And remember now, the general duties, you have to know those
The general duties of each
of the trustee.
of the trustee. Yes, ma'am.
All right, so chapter unit 3 was on classification of trust. Any questions there?
Grasp with no, ma'am. No questions, sir.
So that one is good.
Yes, ma'am.
Okay, all right. That's a boy or girl, the baby?
A girl. She just went to sleep
I
finally.
was about to say, that's why I asked you, because it sound like the baby going to sleep, but I don't want to say baby.
Yes, ma'am.
Okay, so unit 4, validity of a trust.
We could go over that one.
Okay, all right. So once the settlor decides that he wants to create a trust, he has to transfer the legal interest to the trustee. Once he transfers the legal interest to the trustee, the question then comes whether or not the trust has been validly constituted. So, in order to create a trust, certain things have to be in place. First, you must have the 3 certainties.
Yes, ma'am.
You have to meet the formal requirements that are laid down in statute for the creation of a trust. And then you have to transfer the assets to the trustee in accordance with the method for transference based on the type of asset it is. So if it's a car, how do you transfer title?
It's a bill of sale, eh? No?
Yes, and don't you have to sign the decal? On that not the decal now, it's the certificate that you get from road traffic.
Okay.
Yes. So that's what they're saying. You have to, in order for the assets to vest in the trustee, for each asset, you have to know what is the formal method to transfer that title.
Okay.
So it's not just the 3 certainties. But it's making sure that you've met all the formal requirements and that the property has been transferred in accordance with the method.
Okay.
So certainty of words, looking at the 3 certainties. The case for certainty of words is Knight versus Knight. And in that case, the judge said, as a general rule, it has been laid down that when property is given absolutely to a person, and that same person is by the giver who has the power into command, recommend, entreated, or wish to dispose of that property in favor of another, the recommendation, entreaty, or wish shall be held to create a trust. First, if the words were so used that upon the whole, they ought to be constructed as imperative. So now he's telling you is that you have to watch the words that are used to create a trust. Secondly, if the subject of the recommendation or wish is certain. And thirdly, if the objects or persons intended to have the benefit of the recommendation or wish to be certain. So in that whole quote, he's telling you, you need the 3 certainties. So certainty of words or intention. In order for a trust to be held validly created, the court requires that the settlor be shown to have intended a trust. So again, the maxim is equity looks to the intent rather than the form. which means that there is no express expression to determine whether the settlor had the intent. So what the court normally do is they look at the words. And by looking at the words, they determine whether a trust can be construed from those words. So in the case of Reed K. Ford, the judge said in certain circumstances, certain cases, where there are no documents or evidence, the alleged trust, certain words spoken or conduct may show that a trust was intended.
So that's like when it says when you transfer into jurisdictions, you have to be sure that certain words are interpreted the same as from the former jurisdiction.
Yes, and it's also too when someone creates a trust within a will.
Okay.
You have to make sure that that trust is valid.
Okay.
So the first thing is you look at either the words or the intention. So the testator in Stewart versus Fields, he wrote the clause. I hope it will be possible to create a trust after I'm gone to ensure that this land remains forever in the hands of the Stewarts, and that my nieces and nephews always have the above interest, which can be passed on to their heirs and successors. So the testator also added clauses that any proceeds derived from working the land should be distributed amongst his son, nephews, nieces, and aunt in specified proportions, and that at no time should the land be the son's to sell. And the court held that the testator intended to create a trust for the benefit of his son and relatives, identified as beneficiaries in his will. So without satisfying the words of certainty of words or intention, it's important that courts distinguish whether the settlor has the intention to impose a binding obligation, as in the case of a trust, or whether he is using words of anticipation or expectation, which may not be intended to be binding. So whenever you see the words that are being stated, you have to determine whether or not those words are certain, or where the intention of the settlor was certain.
Okay.
So in the case of Adams versus the Kensington Vestry, the testator left all of his estate unto the absolute use of my wife, and full confidence that she will do what is right as to the disposal thereof between my children, either in her lifetime or by will after her decease. And the court held that the gift to be absolute. So that gift, it means that the gift was only for her.
Okay.
Did you see how he worded it, right?
Yes, ma'am.
Absolute use of my wife. So the second one is certainty of subject matter. And subject matter has two elements. What the certainty as to the property to be held in the trust, and certainty as to the extent of the beneficial interest of each beneficiary. So, certainty of trust property is important. As you wake up now?
Yes. Yes, ma'am.
As it allows trustees to know exactly what will be included in the trust and what will be excluded.
Okay.
The beneficial interest of each beneficiary has to be certain in order to enable the trustees to know exactly what and how much each beneficiary will be entitled to receive on distribution, and what income should be accumulated for or paid to the beneficiary. In the case of Boyce and Boyce, the trust failed for uncertainty as the beneficial interest, where testator left several houses on trust for his wife for life and on her death to convey any one house to his daughter Amy as she might choose. The remaining house to his daughter Betty. Amy died before she could make a choice, and so it was left uncertain. So the trust for Betty was void.
I just was about to ask that. So in that case, Betty gets nothing.
That's right.
Mm. So if in that case Betty gets nothing, what would then happen to the houses?
It depends on how the trust is worded. Because
Okay.
remember, trusts at the very end, they have a catch-all phrase.
Okay.
The catch-all phrase is saying, like, if anything is left, it's to go to this person. Most trusts have a catch-all phrase at the very end. I mean, will.
Okay.
Catch-all phrase. Then I gave you the case of Sprang versus Bernard, where the testatress left 300 pounds to her husband for his sole use, and after his death, the remaining part of what is left, and he doesn't want to for his own wants and use, and he has to divide it between her brother and her sister equally. And the court held that this was not a trust for the husband with remainders over, but rather it was an absolute gift.
Okay.
And then Hunter versus Moss, you could read that one.
Okay.
So whenever there's uncertainty as to subject matter of the whole trust, there may be some doubt as to whether the settlor intended a trust at all. The next one is certainty of object.
And that can be determined by how it is worded.
Yes.
Okay.
Certainty of object, which means that you have to know who the beneficiaries are. My old friends, my defendants, there will be uncertainty of objects and the trust will fail because it's not ascertainable. So there are different tests for certainty of objects in fixed and discretionary trusts. For a fixed trust, the test of certainty of objects is that it must be possible for the trustees to prepare a complete list of the beneficiaries. And if this is not possible, the trust will be void. For discretionary trusts, the test for certainty of objects is whether it can be said with certainty that any given individual is or is not a member of the class. So therefore, of discretionary trusts are only required when exercising their discretion to be able to determine if any person who they are contemplating to bestow benefits upon is or is not a member of the class for which the trust was intended. And the leading case for certainty of objects is the case of McPhail versus Dalton.
Okay.
And you could read that case that it talks about the test for certainty of objects. It says that applying the test, the description of the class must not be so obscure as to preclude the trustees from determining whether a given claimant is within the class. Examples of obscurity are any person having a moral claim on the settlor and any old friends of the settlor.
Okay.
The court also imposed another limitation on the trust, and that is the trust will be invalid if the definition of the beneficiaries is so hopelessly wide as not to form anything like a class, so that the trust is administratively unworkable. So McPhail versus Dalton, if you don't remember that case for certainty of objects, you can remember the Bahamian case of Reed Butler, Oaks versus Oaks.
Okay.
And in this case, the testatrix said in her will, I give and bequeath unto my trustees to divide among such of my friend and relatives, living at the time of my death, the jewelry, fine art, and other personality then owned by me, and such shares and quantities as my trustees. She went on. The court held that the certainty of objects was satisfied.
So with that, how do they distinguish who is the friend, is the friends, are the friends names?
Okay, so the court issued the guidelines as was settled in the case of Reed Barlow Wills Trust. And in that case, they defined what are friends. Friends are person that the deceased would have had a long-standing relationship with. They must have had a social relationship. So it can't be business or professional.
Okay.
And although there may have been long periods between them seeing each other, whenever they saw each other, they would have a conversation and catch up on old times. That's a friend.
Okay. That's, I mean, that's understood, right? But still, how?
You have to meet those three characteristics in order to be a friend.
I mean, but I could say that our relationship was a long-standing one.
No, you have to prove that.
Oh, okay. So the court will have to be satisfied with whatever you do or say to prove that that you meet those guidelines of what is a friend is defined as.
Yes.
So in essence, they will make the final decision.
Yes, they will.
Okay.
I mean, that's when you're in doubt now.
Okay. Okay,
So,
I got that.
Got it. So just the requirements for the creation of a valid trust. In addition to the three certainties, the settler's legal interest in the property must be transferred to the trustee in accordance with the formalities of the law, and that allows for the trust to be completely, properly constituted. The object of the trust must also be lawful for the trust to be validly created. Now, the settler's capacity to create a trust is that he has to own the property. And I said that from the very beginning, right?
Yes, well.
He has to own it. There shouldn't be any liens, no debts against it. He also has to be of the legal age, which is 18. And he also have to have the mental capacity. So he has to be of sound mind. The same way like when you're writing a will, you have to have a sound mind. You have to be over 18. Now he can also create a trust of the equitable interest in certain properties as well. Minors, though they hold an equitable interest in real property, do not have a legal interest in such property. Because remember, minors can't hold land. So minors could create trust of the equitable interest in property, and such will become voidable for the purpose of the law until the minor attains the age of 18.
Okay.
So when a settler sits down to create a trust, it's just and he's creating a will. He have to understand what he's doing. Even though he may have had some mental capacity before, he demonstrate that he is coherent, then the will is going to be valid. If he's a person who is in and out of lucidity, then what the court will look at is whether or not he had a history of mental incapacity or whether or not he had lucid intervals, which means there were times in which he was normal. And then we have the rule against perpetuity. And this is the rule prohibiting trusts of excessive duration and any rule of law restricting the period during which income may be accumulated. So the rule against perpetuity is also known as the rule against dead hand control. Invalidates future interest in property which vests remotely. So all this is saying that in the Bahamas, we abolished the application of any applicable rule against perpetuity. And that happened in 2011. That's the baby comment.
I saw you have the hiccups, yes, wow.
Oh Lord, what do people say? Was it to put brown paper over here or
I don't
forehead?
feel like that is work.
I know if it is way.
You're old people have all kind of sayings.
Mm-hmm. You want you? What about 5? Appointment of trustees.
I think that's pretty straightforward.
Yeah, that one is easy. I didn't write that one too complicated. Duties and powers.
I have duties and powers.
Okay, because that one ain't too bad either.
You know.
Trustee remuneration isn't bad either, right?
No, we could go over that one of them.
Trustee remuneration.
Yes, ma'am.
Okay, so when you are a trustee, it's not automatically that you're going to be paid. So normally within the trust deed, a provision is made to remunerate the trustee. So the trustee could charge for his services, but that is not a breach of his fiduciary duty, as long as the provision is made within the trust deed. So if you see a provision in the trust deed for the trustee to be paid, that clause, that provision is called a charging clause. So one of the first thing a trustee will do when he's drafting his trust deed or the trust is being transferred to him is whether or not he's going to be remunerated.
Okay.
So it is even argued that express charging clause in the trust instrument will be allowed, even though it may enable a trustee to gain from his fiduciary position, and even though it may produce a conflict of duty and interest. So even if there is a charging clause in the trust instrument, the trustees may only charge what is reasonable. A trustee is entitled to recover out-of-pocket expenses from the trust estate if they are legitimate. And such expenses include litigation costs or paying fees to agent. And so that means that when a trustee wants to be reimbursed, he has to make sure that his fees or whatever he's charging is reasonable.
So who determines if it's reasonable?
The court.
Okay.
I mean, it depends if it is something that's by nature, most trustees do. All he has to do is do a canvas across the market.
Okay.
So in exercising its jurisdiction, because you can go to the court will take into consideration the following things that was found in the case of Reduke of Norfolk Settlement Trust. They look at the protection against claims of the trustees in light of the gratuitous nature of their office. The trust should be well administered and regard should be paid to the nature of the trust. They look at the experience of the trustee, the amount that he seeks to charge compared to what other trustees might require to be paid for their services, and any other circumstance which may be relevant. So notice in trust law, the courts over time have put a lot of the outlines that are required for certain actions to be done by the trustees.
Okay.
So a trustee can have, the court can say, trustee can be paid for past or future services. The court can increase the remuneration of a trustee where the judge feels that the level is too low. So in the case of Rekeeler Settlement Trust, the court also, using its inherent jurisdiction, permit trustees to keep remuneration they are taken in breach of their fiduciary duty and ordered an inquiry as to future remuneration from some of its trustees. So notwithstanding the fact that such agreements are rare due to allegations of undue influence, which may be made against them. Trustees may contract with beneficiaries who are sui juris and absolutely entitled for remuneration. And some beneficiaries will be bound by these agreements. So where trust assets are situated abroad, and the law of the country where the property is situated allows trustees to receive remuneration and trustees under a Bahamian or UK trust. To receive such remuneration, they will not be bound to account for it unless they went out of their way to obtain it. And of course, there's the rule in Keach versus Sanford. And that states that the trustee must not allow his interests and duties to conflict. And a trustee is not allowed to take any profits from his trust as trustee unless those profits have been authorized by the trust instrument. Did Ms. Dane send you a copy of the trust instrument we discussed in class?
No, ma'am.
Okay, I gotta make sure you get that for tomorrow.
Okay.
So a trustee cannot purchase trust property for himself. This is not a duty imposed on trustees, but a disability. Any purchase of trust property by a trustee at the instance of a beneficiary will be voidable, no matter how fair, open, or honest the transaction may have been. So that's
Okay.
remember.
Yes,
You
ma'am.
want to stop for the night and then we finish it tomorrow, or
Okay, we can.
because you have to deal with the baby?
Yes, ma'am.
Yeah, I had sent two. I think I sent two. Let me ask.
Okay.
I could send her a text and I'll tell her which chapters you could do tomorrow. I mean, we could finish it, but
We can
which one?
finish because we already on chapter 7 tonight.
Yeah, so 8, 9, and 10,
Yes, ma'am.
and 11. Okay, all right. Let me send her a note right now to send you the 2 trustees.
Okay.
Okay?
Yes, ma'am.
All right. So
Thank
6:30
you
is
so
good
much.
or 7?
Whatever works for you.
No, you get the baby. That's why I asked you.
We can do 6:30.
Okay, all right. So I'll tell Miguel to put it on again for 6:30 tomorrow.
Okay. Thank you so
Okay?
much, Misato.
You're most welcome.
All right.
Okay.